The morning I found out my husband had been moving our money for 11 months, I was sitting at the kitchen table in my robe with a cup of coffee that had gone cold, looking at a bank statement that did not match what I thought I knew about my own life. The number at the bottom of the page was not wrong. It was precise. It was exact. It was the product of 11 months of careful, methodical, deliberate movement of funds that had been conducted by a man I had been married to for 19 years, and accounts I had trusted him to manage because that had been our arrangement, in amounts calculated to stay just below the thresholds that trigger automatic flags. $3.2 million. That was the total that my attorney would eventually lay out in a courtroom document. $3.2 million in assets, properties, investment accounts, a business interest, and a retirement fund that had been quietly, systematically transferred, restructured, encumbered, or hidden in the 11 months before he told me he wanted a divorce. And what he did not know, what he could not have known, what he had not accounted for in 11 months of careful planning, was the one thing his attorney should have told him to find. He missed it. And 1 month after he filed, the court revealed it, and everything he had built to protect himself from me became the exact architecture of his own undoing. My name is Catherine Aldridge. I am 47 years old. I live in a house in Scottsdale, Arizona, that is mine, legally, completely, not in dispute, and I have a life that I have rebuilt from the inside out over the past 2 years in ways I am still discovering. I am a licensed interior designer. I have my own firm, 12 years old, 14 employees. Clients across the Southwest who have trusted me with their spaces and their investments, and sometimes their most personal moments. I am also, as of 22 months ago, a woman who understands financial documents better than she ever expected to, and who will never again trust the management of her own life to anyone else's hands. Not because I am bitter, because I am educated. There is a difference, and understanding that difference is the reason I'm sitting here today. If you are new to the Revenge Diaries, subscribe right now and hit that like button. This community is built for stories about real people and real outcomes, told without drama and without apology. And before I go further, drop a comment and tell me, have you ever signed a document you did not fully read because you trusted the person handing it to you? Yes or no? I'll be reading every single one. Now let me take you back to where this actually started. My husband, his name was Graham Aldridge, and I use the past tense because the person he turned out to be is not someone I was ever actually married to. Was 51 years old when this began. He was a commercial real estate developer. He had built his business before we met, and I had over 19 years become increasingly integrated into its operations, not as an employee, but as a partner in the practical sense of the word. I reviewed vendor proposals. I managed the aesthetic and presentation dimensions of high-end commercial developments, which was how we had met and how my design work had always connected to his real estate work. I had signed documents. I had sat in meetings. I had contributed to deals that had added significantly to the portfolio that he was now, apparently, working to remove me from. The thing about a long marriage is that trust accumulates in layers. 19 years of layers. 19 years of assumptions that become invisible. I do not need to check that because Graham handles it. I do not need to read that because we have always done it this way. I do not need to verify that because we are a team. The invisible assumptions are what make financial betrayal in a marriage different from other kinds of theft. It is not opportunistic. It requires the specific, intimate knowledge of what your target trusts and what they do not question. Graham knew exactly what I trusted and exactly what I did not question. He had 19 years of research. He told me he wanted a divorce on a Tuesday evening in January. We were in the kitchen. I was finishing a presentation for a client meeting the next morning. He came in from the garage, still in his coat, and he said, "Catherine, I need to talk to you." I turned around. His face had the specific stillness of a person who has rehearsed a conversation many times and is now delivering the rehearsed version. He said, "I don't think we want the same things anymore." I said, "Graham, what are you talking about?" He said, "I've spoken to an attorney. I think it's better if we both do." That was the complete conversation. 3 sentences from him and 1 question from me. And then he walked down the hall to the guest room. And I stood in the kitchen with my presentation open on the laptop, and I did not move for about 4 minutes. I did not cry that night. I want to be honest about that, because people sometimes expect crying to be the first response, and it was not mine. What I felt was something colder and more alert. Something that sat up in my chest like an antenna turning. because Graham's face in that kitchen had not looked like a man who was sad about the end of something. It had looked like a man who had completed a task. And I'd spent 12 years running a business that required me to read rooms and read people, and the reading I got from Graham's face in that kitchen was not grief. It was relief. And relief, when you have been married to someone for 19 years and they have just told you they want a divorce, means something has already happened that you do not yet know about. I called my attorney the next morning. Her name is Rachel Navarro. She is 53 years old and has been practicing family law in Arizona for 27 years and has, in her own words, seen every variation of financial manipulation in a divorce that the human imagination has produced. I had met Rachel at a professional event 4 years earlier and had kept her card not because I expected to need it, but because she had struck me in a 20-minute conversation as the kind of attorney you want in your corner when things are serious. I called her at 7:45 in the morning before my client meeting. I told her what Graham had said, and I told her what I had seen in his face. She said, "Do not sign anything, do not move any money, and get me every financial statement you can access in the next 24 hours. She said, "You may have less time than you think." I did not fully understand what she meant by that yet. I canceled my client meeting. I spent the morning at my computer pulling everything I could access. Our joint checking account, our joint savings, the brokerage account I had access to as a co-holder, the statements I could retrieve for the investment property portfolio. There were 6 properties, 4 commercial and 2 residential, all acquired during the marriage, all held in a combination of our names and LLCs that Graham managed. I pulled 3 years of statements. I printed them on the printer in my home office. I put them in a folder. I drove to Rachel's office at noon, and she sat across from me and she went through the folder with the focused attention of a person who knows how to read financial documents, the way I know how to read a floor plan, for what is there and for what is conspicuously absent. She said when she finished, "Catherine, I need you to listen to me carefully." She folded her hands on the desk. "Based on what you have brought me, there is evidence of significant financial activity over the past year that requires immediate and thorough forensic accounting." She said the word forensic the way doctors say certain words, precisely, without alarm, but with the weight of what it means fully present. She said, "We are going to need a forensic accountant, someone who specializes in marital asset dissipation and financial concealment. I have someone I work with regularly. I want to bring her in immediately." I said, "How bad is it?" She said, "I don't know yet, but I know enough to know we need to move quickly." The forensic accountant's name was Sandra Park. She was 48 years old, had a background in financial fraud investigation before moving to private practice, and had a manner that was simultaneously warm and completely without sentiment about the numbers in front of her. Sandra did not deal in feelings. Sandra dealt in documentation, and the documentation she uncovered over the following 3 weeks, working from the statements I had brought to Rachel's office and from the subpoenas Rachel filed immediately in the Arizona court system, was one of the most systematic pictures of marital asset dissipation that Rachel, in 27 years of practice, said she had encountered. Here is what Graham had done. Over 11 months, beginning, Sandra determined, approximately 3 months after what would have been a significant, and I believe, planned conversation between Graham and someone else that I will get to, he had undertaken a structured program to reduce the apparent value of the marital estate. He had encumbered 2 of the commercial properties with new mortgages that did not appear in the statements I had access to, reducing their equity significantly on paper. He had transferred the operating interest in his development company from the LLC structure we held jointly to a new LLC formed under his name alone, arguing in the paperwork that the company had been independently valued and that the transfer reflected a debt settlement. He had moved funds from our joint brokerage account in incremental transfers, 17 transactions over 9 months, each below the amount that would have required my co-authorization, into a separate account I did not know existed. He had borrowed against the cash value of a life insurance policy without disclosure, and he had, most significantly, created a paper trail suggesting that the most valuable of the residential properties, a property we had purchased together in 2018 and that had appreciated substantially, was encumbered by a private loan from a business associate, reducing its apparent equity to near zero. Total value structured out of the apparent marital estate, per Sandra's preliminary analysis, $3.2 million. $3.2 million. I sat in Rachel's office on the Thursday afternoon. When Sandra delivered that number and I looked at it on the paper Sandra had placed on the desk between us, and I felt something I want to describe as accurately as I can. I felt the specific, clarifying cold of understanding. Not shock, because some part of me had known from the moment I read Graham's face in the kitchen on that Tuesday evening that something structural had already happened, but understanding. The full architecture of what had been built in 11 months by a man who had known how I trusted and what I did not question. I did not cry in that office. I looked at the number and I said, "What did he miss?" Sandra looked at me. Rachel looked at me. Sandra said, "What do you mean?" I said, "A man who does this kind of work for 11 months is careful. He is methodical. But he is not infallible. What did he miss?" Sandra smiled, the first time I had seen her smile in 3 weeks of very serious work. She said, "That is exactly the right question. I want to stop here because this is the pivot point of the entire thing, and I want you to understand what I mean when I say it. In a divorce involving financial concealment, the question is never just what was hidden. The question is always what was forgotten, because concealment is human work, and human work has gaps. The person who conceals has to remember everything they changed. The person who investigates has to find only one thing they forgot. And Graham, in 11 months of careful, systematic work, had forgotten one thing that he had not thought to address because it was old and quiet and had been sitting undisturbed for so long that it had become invisible to him the way long-standing things become invisible. And what he had forgotten was the thing that, 1 month after he filed, the court would reveal in a document that changed the calculation of the entire case. The thing Graham forgot was my name on a deed. 11 years earlier, in the early years of our marriage, Graham had purchased a piece of commercial land on the eastern edge of the Phoenix metropolitan area. He had purchased it as a speculative investment, raw land, undeveloped, in an area that had not yet attracted the development interest that was beginning to move in that direction. At the time of purchase, for reasons I do not now fully remember, but that likely had to do with the structure of the acquisition financing, the deed had been recorded in both of our names. Not in an LLC, not in Graham's name alone, in both of our names. As tenants in common, which in Arizona has specific legal implications for how property can be transferred and encumbered, the land had sat 11 years. Undeveloped, unencumbered, unremarkable on the surface. And over those 11 years, the development interest that had been beginning to move in that direction had moved in that direction considerably. The land, which Graham had purchased for approximately $340,000 in the early years of our marriage, had been appraised in a report commissioned by a developer who had approached Graham about a potential sale at $2.1 million. Graham had not disclosed this property in the initial financial disclosures he filed with the court when he submitted his divorce petition. He had not listed it. He had not flagged it. He had not encumbered it or restructured it or created a paper trail of private loans against it the way he had done with the residential property. He had simply not included it. Whether this was an oversight, which Rachel considered unlikely given the systematic nature of everything else, or a deliberate omission that he believed would not be caught because the property had been quiet for so long, which was Sandra's assessment, the effect was the same. A $2.1 million asset was not in his disclosure, and my name was on the deed. And Rachel filed a motion for discovery of undisclosed assets within the first 3 weeks of the case, and in the documentation that came back through the court's process was a title search that included every property in which either party held an interest. And there it was, recorded 11 years ago, 2 names on the deed. Current appraised value $2.1 million. Not in Graham's disclosures, found, documented, presented to the court. I want to tell you what happened in that courtroom moment because I think it is the part of this that most requires honest description. Rachel submitted the title documentation as an exhibit at a preliminary hearing on financial disclosures, a procedural hearing, not a trial. Not dramatic in the legal drama sense. There was no jury. There were attorneys, a family court judge named Judge Patricia Weston, and the court record. Graham's attorney, a man named Briggs, who had been practiced and smooth in every communication up to that point, looked at the exhibit when Rachel submitted it. He looked at it for a long moment. He leaned over to Graham. Graham looked at the document. And Graham's face did something in that courtroom that I had not seen it do in 19 years of marriage. It lost its composure. Not dramatically, not the way it happens in movies. Just a small, specific collapse in the area around his eyes. The look of a man who has just understood that the one thing he forgot was also the most important thing. Judge Weston ordered an immediate and complete financial accounting. She appointed an independent forensic examiner, in addition to Sandra, who continued working for our side, to review the full scope of the marital estate. She issued injunctions against any further transfers or encumbrances on any asset in which either party held an interest. And she noted, in her written order, that the failure to disclose a $2.1 million asset in initial financial filings was a matter she intended to address directly in the course of the proceedings. That language, a matter she intended to address directly, became very significant in the months that followed. What would you have done in that moment? When the thing you have been working toward, the documentation, the investigation, the patience of 3 weeks of forensic accounting, arrives in a courtroom and lands exactly the way you needed it to land? I want to know your answer in the comments. Because my answer surprised me, I did not feel triumph. I did not feel vindication in the clean, satisfying way that the word suggests. I felt something more complicated. I felt grief for the marriage I had believed I was in, and was now looking at the complete blueprint of what it had actually been. And underneath the grief, steady and unmovable, I felt something I can only describe as resolve. Not anger, resolve. The clear, directed determination of a person who has found the ground under her feet and intends to stand on it. The case took 14 months from filing to final decree. I will not pretend those 14 months were easy, because they were not. There were depositions in which I sat across from Graham's attorney and answered questions about our financial history while keeping my voice level and my documentation organized. There were months in which the investigation surfaced things about Graham's financial activities that were progressively more difficult to absorb, not because of the money, though the money was significant, but because of the picture they assembled. 11 months of systematic planning. Accounts opened while we were still going to dinner together and attending his company events and behaving in every visible register like a functioning marriage. The planning had been happening while I was cooking dinner, while I was finishing presentations, while I was building my firm. He had been at a parallel desk doing the opposite of what I was doing, and I had not known. The business associate whose name appeared on the private loan paperwork against the residential property was deposed. His testimony under oath was that the loan had been Graham's idea, that the documentation had been prepared by Graham's attorney, and that he had signed it in exchange for an agreement that he would receive a finder's fee on a future development deal. The loan was determined by the court to be a sham instrument, a created debt designed to reduce apparent equity with no genuine financial substance behind it. The 2 commercial properties whose mortgage had reduced their apparent equity were examined by the forensic examiner appointed by the court. The examiner determined that the mortgage proceeds had been deposited into the account I had not known existed, the same account that had received the 17 incremental transfers from the joint brokerage. The account that Graham had not disclosed. The account that, once it surfaced, contained an amount that changed the financial picture of the case significantly. Sandra's final accounting, accepted by the court as the basis for asset division, put the total marital estate at approximately $4.9 million. Not 3.2, 4.9, because what Sandra had found over 14 months of investigation was not only what Graham had tried to remove, but what he had accumulated in the process. The undisclosed land, the hidden account, the recovered equity from the sham mortgage instruments, all of it returned to the picture. All of it subject to the equitable distribution that Arizona family law requires. Rachel argued effectively and at length about the bad faith financial conduct and its implications for how the court should approach the division. Judge Weston, in her final decree, was not restrained in her language about what the documentation showed. She used the word concealment. She used the phrase deliberate and systematic. And the division she ordered reflected both the equitable baseline and the conduct she had observed over 14 months of proceedings. I received the residential property outright, the one against which the sham loan had been attached, free and clear once the court voided the instrument. I received my share of the commercial land that Graham had failed to disclose, the $2.1 million piece of land with my name on the deed that he had bought 11 years ago and apparently forgotten about for 11 months of systematic planning. I received a cash settlement drawn from the recovered hidden account. I received my design firm, which had never been in dispute, but which Graham's attorney had attempted at one point to characterize as a marital asset subject to his claims, an argument that Rachel dismantled with 3 years of business documentation and an expert witness. And I received, less visibly but more meaningfully, the understanding of my own financial life that I had not possessed before any of this began. Have you ever had to rebuild your understanding of something you believed was solid? A relationship, a business, a version of your own past, and found that the rebuilding taught you something the original never did? That is what this process gave me, alongside everything the court returned. I understand balance sheets now in a way I never did when Graham was managing them. I understand the difference between legal ownership and practical control. I understand what a forensic accountant does and why the ability to commission one is one of the most significant practical tools available in a contested financial proceeding. I want you to share your version of this in the comments. What did the hard thing teach you that the easy version never would have? Graham's attorney, Briggs, submitted a motion for reconsideration of the decree that was denied within 3 weeks. Graham filed an appeal, which was also eventually denied, though that process extended the final resolution by several additional months. During the appeal period, I continued running my firm, continued completing client projects, continued building the professional life that had never stopped moving even during the 14 months of the case. I hired a financial advisor, a woman named Dr. Elaine Chu, who specializes in post-divorce financial reconstruction for women and who spent 3 months helping me understand every asset I had been awarded in terms of its long-term implications. Not just what it was, what it would do, how it should be managed, what decisions I needed to make about it in the next 6 months, the next year, the next 10 years. I had been managing an interior design firm for 12 years. I had never managed my own wealth with this level of direct engagement. I started. The undisclosed land sold 14 months after the final decree, not to Graham's original potential buyer, who had withdrawn during the litigation, to a different developer who had approached me directly through Dr. Co's network. The sale closed for slightly above the appraisal. I was the only name on the closing documents. The proceeds went into an account that I had opened under my name alone on the day Rachel filed the initial petition, a step Rachel had recommended and that I had taken before I even fully understood why it mattered. I understand now exactly why it mattered. 2 years later, the residential property has been renovated by my firm using my team on a timeline I chose and is currently leased to tenants who treat it exactly as well as I hoped they would. I live in a house in Scottsdale that I selected in a neighborhood I chose, with a yard that has exactly the garden I wanted, and a kitchen that I designed myself with the specific practiced confidence of someone who has spent 12 years designing spaces for other people and has finally turned her full attention to her own. I have a dog named Archer who is completely uninterested in financial documents and extremely interested in the garden. I have a therapist named Dr. Morris whom I see every 2 weeks and who has helped me understand that what happened to me was not a failure of my intelligence, but a function of trust that was deliberately exploited, and that the correct response to deliberately exploited trust is not the elimination of trust, but its reconstruction on a foundation of information rather than assumption. Graham, as far as I know, is managing the remnants of his development business under significantly reduced circumstances. The sham loan instrument, once it was voided by the court, created consequences in his professional relationships that Rachel had predicted would follow. The business associate who had signed the paperwork was not inclined, after his deposition, to participate in further arrangements with Graham. The investor relationships that had depended on Graham's reputation for straightforward dealing were affected by the public record of the proceedings, which is exactly as public as Arizona court records are, which is to say, fully. I do not follow his situation closely. I have my own situation to follow. I want to talk about my daughters before I close. I have 2 daughters, Nora, who is 22, and Sophie, who is 18. They were old enough to understand something of what was happening during the case, not in the financial detail, but in the human reality of it. I was careful about what I said to them and how I said it, not to protect Graham from accountability, but to protect them from the specific damage that comes from watching a parent perform bitterness. I told them that their father and I had a serious disagreement about how we had managed things together, and that the court was helping us resolve it. I told them that the outcome, while it had taken time and had been difficult, was correct. Nora came to Scottsdale for a long weekend, 2 months after the final decree, and sat with me in the kitchen on a Saturday morning and said, "Mom, are you actually okay?" And I looked at my daughter, 22 years old, her father's eyes and my stubbornness, and I said, "I am more okay than I have been in longer than I knew." She looked at me for a moment. She said, "That's not sad." I said, "No, it's the opposite of sad." She nodded. She helped me make breakfast. We sat at the kitchen table in the Scottsdale house and we talked about her life and her plans and her ideas and her future. And I did not think about Graham's face in the kitchen on the Tuesday evening he had told me he wanted a divorce, the face of a man who had completed a task. I thought about Nora's face. I thought about Sophie, who was in her first year of college and who had texted me the day after the final decree with a single message. "You did it, Mom." I had sat with that text for a long time. I still have it saved. Here's what I want to leave you with, because I've been thinking about how to say it in a way that is honest and useful, and not the kind of thing that sounds like a poster on a wall. If you are in a partnership, a marriage, a business arrangement, any shared financial life, and you have given that partnership your trust by removing yourself from the information that underpins it, I want to ask you to reconsider that arrangement. Not because you should assume betrayal, not because trust is wrong, but because trust and information are not opposites. You can trust the person you are with completely and still know what you own. You can love your partner fully and still read the documents you sign. You can be in a good marriage and still maintain your own understanding of your own financial life. In fact, the best version of a financial partnership is one in which both people can answer the basic questions: what do we own? What does it cost? What have we signed? Not because they expect the other person to fail them, but because that knowledge is part of what makes the partnership real. What made me vulnerable was not my trust. What made me vulnerable was the gap between my trust and my information, and closing that gap is not a betrayal of love. It is the most responsible thing you can do for yourself and for everyone who depends on you. $3.2 million in assets were moved, restructured, encumbered, or hidden in 11 months by a man who believed he had been thorough. One piece of land, recorded 11 years earlier, with 2 names on a deed, had been there the entire time. The court revealed it. And everything Graham had built to protect himself from me became the architecture of his own undoing, not because I was lucky, because Sandra Park was methodical, because Rachel Navarro was relentless, because Judge Weston read documents carefully, and because 11 years ago someone filed a deed with my name on it, and that name had never been removed and had never been forgotten. Not by the county recorder's office, not by the court's title search, not by me. My name was on that deed. My name was always on that deed. And in the end, that was enough. If this meant something to you today, a recognition, a shift, a moment where you thought about something you have not been looking at closely enough, please like this video, subscribe to the Revenge Diaries, and share it with someone who needs to see it today. Final question before I go. Are you managing your own financial information right now, or are you trusting someone else to manage it for you? Just answer honestly in the comments. One sentence, no judgment. And next week on this channel, the story of a man who discovered that his business partner had been selling the company's assets to his own LLC for 3 years, and the single vendor invoice that unraveled everything. I will see you there.